Okay. Good evening, everyone. You are welcome to week 6 of our mentorship program. Please confirm if you can both see and hear me.
And see and hear you.
I can see and hear you loud and clear.
Okay. Okay, you are welcome once more. My name is Jude Ayua. I'm a legal practitioner, currently serving as a UCO member in Ibadan. And I'm also a virtual associate with Infusion Lawyers. I'll be your mentor for today. Sorry, I'll be your anchor for today. I have to wait for my time to become a mentor. Okay, so you are welcome once more. Our topic for today is intellectual property registration, infringement, enforcement, and availability and arbitrability of intellectual property disputes. But before we go into that, we'll be taking the information about the program. As you can see, it's projected here. The JIIPCC Intellectual Property Mentorship and Internship Program. It's a quarterly program for students, young professionals, and enthusiasts across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. The program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching for JIIPCC on YouTube and Facebook with the hashtag JIIPCCMIP. And the following are the objectives of the program. A, to provide easy access to quality professional guidance, training, and resource materials for students, young professionals, and enthusiasts in Africa. To facilitate dialogue and network among experienced and less experienced practitioners and stakeholders. To transform mentees into mentors and leaders for the next generation of mentees. To facilitate further mentorship, internships, scholarships, and job placements for the mentees. Okay, so before we continue into the presentations, kindly take notes of the following announcements. The 30 minutes private mentorship with mentors is still available. You are encouraged to, while the program is on, you are all encouraged to put on your videos so that we have an interactive session here. Do note that we're also live streaming. And once you log in, for those of you who are already here, kindly edit your name. Kindly edit the name section on your Zoom account so that it carries your name. This is to ensure that your attendance is recorded for this session. Also note that registration for the second quarter of the mentorship is on. Kindly share the information with your friends and colleagues. Okay, so for all the groups that are present, note that you have 8 minutes each for your presentation. I don't know if all representatives are present here, but we'll be starting with group 1. So are you ready to start group 1? Hello? Group 1 is not ready. How about group 2?
Good evening.
Okay.
Good evening, everyone. My name is Olumegbola Damdola. Solomon, please, are you present? Okay. Here, please kindly share the screen.
Okay, yes, before you proceed, participants, if you can please put on your videos, okay? Thank you. You can proceed.
Okay, good evening, everyone. My name is Olumegbola Damdola, and I'm representing Group 2. Our topic for this week borders on infringement of intellectual property. So before I go further, I would like to, state what intellectual property is. Intellectual property is the creation of human minds. Now, what intellectual property right is the exclusive right that a creator has over his own creation, his work. The laws that now govern intellectual property are the laws that are put in place to ensure that the rights of an author is not being infringed upon. For weeks now, we've been discussing what intellectual property is all about. Intellectual property can be, classified into two parts. That's industrial property and copyright and related rights. Under industrial property is where we have trademark, industrial design, patent, geographical indication, and trade secret. So what do we now mean by infringement of intellectual property? It basically means the violation of the rights, the exclusive rights of the owner of an intellectual property, or the unauthorized use of intellectual property that does not belong to you without the permission of the owner of the intellectual property. Anybody that does anything ultra via another person's right is basically breaching on the owner's right. That's basically what intellectual property. Hold on. Okay. Can you see it, Oma? Can you see it, Oma? Okay. That's what intellectual property is all about. Now, if we're saying intellectual infringement, all these kinds of intellectual property, that is trademarks, patents, industrial designs, copyright, they can all be infringed upon. If they're infringed upon, it basically means that somebody else is misusing another person's property without authorization whatsoever from the owner. And that's what I mean by doing any act that is ultra vires of the owner's right. So now, if we're going to talk about copyright infringement, Section 15 of Copyright Act basically says that copyright infringement would occur. That section stipulated a lot of ways in which a copyright can be infringed upon. However, I will just sum it up in this phrase by saying that copyright infringement will occur whenever a person carries out or induces another person to carry out the exclusive function of a copyright owner, whereby you use another person's rights without authorization, you are infringing on that person's right. So a classical example would be, a relatable and classical example would be the case of this popular guy, Goya, the hype man that sang Bam Bam, Beyond Bam Bam and all of that. So what he did, he and a Ghanaian producer, Neptunes, they took a song rather, that does not belong to them. It belongs to one man from Eric Levy, yeah, and his group. The song that originally belongs to them. The Ameno sound was from their album named Era. So they took that sound and then they imputed his own lyrics. However, if you're listening to that song very well, at the background, you can still clearly hear the beats and the lyrics that was originally used. So what Spotify did in this instance was Spotify took down that song from their platform because of copyright and license infringement. The reason being that the owner of the original song never gave consent for them to go ahead to use the song. So Spotify contacted the owner of the songs and, asked them if there's been an agreement or a license agreement between the hype man and them. But they said no, and they didn't give consent to it. So they avoided themselves from being a secondary infringer, in the sense that if the original owner were to institute an action today for breach of their rights, aside from the fact that Goya, that's the hype man, is going to be a primary infringer, the streaming platforms, any other streaming platforms too, would be a secondary infringer. What I mean by primary and secondary infringer is the sense that the primary infringer is the original person that was directly involved in the process of infringing on another person's right, while the secondary one is, they are not, the secondary party are not directly involved, but in a way they have contributed to the own negligence, to the infringement. So in order to save themselves, they took down the song from their platform. That's a classical example of, copyright infringement. Because if they were to continue that way, they are at risk of, losing money and then going to court back and forth. It's not preferable for them. So now I'll talk about trademark infringement. Trademark infringement also means we've defined trademark as a sense that, we define trademarking as, logos, name, anything that differentiates a company's goods and services from another. That's trademark. So the infringement would be in the sense that if another person, copies a product that has already been infringed, or a product that was already a product or services that has already been registered without authorization, they are infringing on that right. If they make a similar, product or services, they are infringing on that right, on the right of the owner. So in order to prove copyright infringement, what you have to prove is if it is similar, if the products are similar or the goods or services are similar, and it's capable of influencing the decision of the consumers, people that are going to consume. Sir.
Yeah, sorry, you have to round up. Quickly summarize.
Okay. With this whole infringement, if the rights of the owners are not properly protected, there's going to be back and forth. And in the first thing that people do in infringement issues, they send a protest letter out to the infringing party, informing them to desist from infringing on their rights. If they fail to do so, they can as well go to court to institute an action to buttress their points and claim their rights back. Thank you.
Okay. Thank you, Damilola. On behalf of Group 2, that was insightful, even though you didn't have enough time to finish, but we got something. So Group 1, are you ready now, or should we proceed to Group 3? Is Group 1 ready? Anthony, I think you are trying to say something, but I can't hear you. Okay, Onyeka Chukwu, are you for Group 1?
I said I'm ready to present for one.
Not.
Okay. Anthony, am I the only one, but I can't hear you. I think you need to get better connection.
Anthony is presenting for group one. I think he has network issues.
Okay, Anthony, hold on. I think you should sort that out while we proceed with group 3, just to save our time. Sorry. Anthony, you can pause. Then we'll go on to group 3. So group 3, you can proceed.
Hello, sir. The presenter is trying to log in. She'll be with us. You'll be with us in a moment. I'm so sorry.
I didn't get you said.
The presenter is trying to log in. You'll be with us in a moment, sir. He has been having trouble logging in.
Okay. I'm from.
No, the line is actually breaking.
Everybody.
Yes, good evening. You can proceed.
So for the investment, so I'm presenting for 3.
Can we hear from group 4 while group 1 and group 3 are sorting out their internet issues?
Okay, group 3, kindly stop sharing your screen. Let's go to group 4. Please try and sort out your network issue. Okay, thank you. So group 4, you can proceed now.
Good evening, everyone. Good evening, Ms. Juliana. Good evening, Jude.
Good evening.
The arbitrability of IP disputes. We'll be going right into it by beginning with the nature of IP disputes. Due to the development of intellectual property in the world, disputes regarding this intellectual property have arisen, and also litigation, being the foremost dispute resolution method, has begun to rescind, and other alternative dispute resolution methods have been adopted, one of which is arbitration. Discrepancies to settle the discrepancy regarding the contract in which they have entered. And pursuant to Nigerian law, the Nigerian Constitution, Section 251, it provides that the Federal High Court has the jurisdiction to hear IP disputes. However, the Section 17 of the Federal High Court Act provides that the court may promote reconciliation among parties, and therefore it encourages and facilitates the amicable settlements, and thereby promoting arbitration. Also, the Section 13 sub 3 of the Trademark Act provides that when two people who have the same goods come to the registrar to register those goods, the registrar may order them to go to the court to settle these discrepancies, or order them to settle it by any other way. Yes, and when the registrar orders them to settle it by any other way, arbitration comes in as another dispute resolution method which the parties can adopt. Next slide. Well, on to the next slide. So the Hong Kong and Singapore examples. Now, in other countries, in example, in Hong Kong, in 2018, they enacted the Hong Kong Arbitration Ordinance, which now clarifies that all IP disputes, including the enforceability, the validity, ownership of IP can be arbitrated upon. Also, in 2019, Singapore passed the Intellectual Property Dispute Resolution Act, which amends their former Arbitration Act and now clarifies that IP disputes can be arbitrated, including the scope, the enforceability, infringement. It also provides that an arbitral award is not deemed contrary to public policy solely on the basis that the subject matter relates to an IP dispute. The next slide, please. Okay, now, what is the nature of arbitration and how does it relate to intellectual property? As we know, the foremost method of dispute resolution is litigation. However, arbitration is an alternative dispute resolution procedure in which a dispute is submitted prior to the consensual agreement of the parties stated in that contract that they will take their dispute to an arbitrator in an arbitral tribunal, who will then make a binding decision and maybe order an arbitral award. Internationally, arbitration is administered by the New York Arbitration Convention on the recognition and enforcement of foreign arbitral awards, New York. Okay, to the next one, the nature of IP arbitration and IP continued. Most IP disputes are brought to arbitration revolve around contractual issues. These are when a party or a person, a licensor, licenses or assigns his license to other parties known as the licensees, and then these parties infringe or surpass the license that was given to them. They can be these contractual disputes can be arbitrated upon unless they revolve around registration or the validity of IPR, that is intellectual property rights. In the two cases on the screen, the courts held that intellectual property rights arising from statutes are not arbitrable, and only those rights that are arising from contractual obligations can be arbitrated upon. In this scenario, the arbitral proceedings will be stayed upon, while the party alleging that his right has been infringed upon will have to institute a case in the court to show that actually his intellectual property is valid. And then when the court has determined that his intellectual property is valid, then the arbitral proceedings will then resume, and the arbitrator will then decide who is right and who is wrong. Actions arising from illegal acts are not arbitrable. Sorry, Chisom, please go back to the next. Yes. Actions arising from illegal acts are not arbitrable. Portion 2, and this is also held in Nigeria. In Nigeria, portion 2, section 55 of the Arbitration and Conciliation Act. Actions arising from illegal acts are not arbitrable. Actions involving tax, only actions of commercial transactions and contractual obligations are arbitrable. Please, to the next slide. The settlement of IP disputes by WIPO. Okay, so the WIPO Center of Arbitration is one body of the WIPO organization, and this center provides speedy alternate dispute resolution methods such as arbitration, mediation, conciliation, of which arbitration is the foremost. Under this, we have 2 case studies. But in these case studies, due to the confidentiality of arbitration issues or disputes, the names of the parties are not mentioned. However, the first case study is a US company which entered a technology licensing agreement with a licensor, a German company. And okay, in that agreement, it was contained that they will be subject to weapon. There was included in the contract a WIPO arbitration clause, and also the contract provided that the national laws of a European country will be subject to the procedure. Some years after the contract was signed, the licensor claimed that the licensee infringed on his rights. There was a breach of contract and the breach of trade secrets provided by the license. So during the proceedings and due to the counterclaims made by the respondents, the claimants held objected to the jurisdiction of the arbitral tribunal, and then and filed a request for arbitration. And after all these consultations, after the arbitral tribunal had read the written proceedings, and after holding a 3-day hearing at Geneva, it held that the licensor's intellectual property rights had been infringed upon, and it stopped or it banned the licensee from carrying out from using that license or use making use of the intellectual property that was licensed to him by the licensor. So the second case study is a company that provided wireless communication services and a company that sells and installs these infrastructure.
Hello, Glory.
Yes, hi, Jude.
Okay, kindly round up now.
All right. Hi, Chisom, please go to the next slide. The possible improvements on the arbitrability of IP disputes. We have seen that litigation is not the only dispute resolution that can
Gloria, are you still on?
okay. So
I think you should round up now. Okay, thank you so much for your presentation. That was very insightful. I learned a lot personally. So group 1 or 3, which of you are ready to proceed now? Group 1 or 3, anyone available?
We are ready, sir.
Okay. I think you should be louder. I can hear you very clearly. Not loud enough yet. Sorry. Can anyone else hear him? Hello, Nifemi.
Hello, yeah. Can you hear me now? Oh, but no, can you hear me now?
Yes, it's quite better. I think you can
go ahead. Hear you.
Okay, thank you. So good evening, everyone. I'm sorry I won't be able to share my video. I'm having issue with my laptop camera. I don't know why.
No problem.
Okay. Okay. So that's the issue. It comes up and off. Okay, so we are discussing on IP enforcement, the enforcement of intellectual property rights. So I will start by saying that we have been discussing IP rights and intellectual property, but the basic thing is that if there is a right and there is no way to enforce it, then there is no right. Then you can actually say that there is no right. So the main aim of having rights is to have it enforced. And on the other hand, even when there's a difference between having a means of enforcing a right and enforcing that right, which is where I believe we as practitioners and others comes in, the enforcement of intellectual property rights, or else it will become a dead right, so-called. So according to Priori Legal, so IP enforcement is defined as any legal actions you take to maintain your IP rights and ensure that no third party use them without proper authorization, as well as obtaining compensation for losses when they do. Basically, enforcement of IP rights is basically needed, at least to ensure that the legal validity of your IP right is preserved, to prevent frequent occurrence of infringements by third parties. So basically to ensure that you are able to use your IP right to the fullest, to avoid damage, including loss of cost, goodwill, and reputation. IP right is basically to ensure that the owner of IP or the owner of the IP rights enjoy the full benefits of the IP right, and no one exploit the rights without the approval of the owner. Then we have the relevant rules concerning the enforcement of intellectual property in Africa. Okay, so yes, IP right is not just in Nigeria. Since we are discussing as the world as a whole, we are starting with Africa. Yeah, we said that intellectual property right in Africa is regulated by laws, statutes, treaties, conventions, and agreements. We have the national laws, and we have some on the international levels by the intellectual property organization, the likes of ARICO, African Regional Intellectual Property Organization. We have the Africa formerly known as African Regional Industrial Property Organization is an intergovernmental organization in Africa that is set to play a significant role in strengthening cross-border collaborations on intellectual property rights under the African Continental Free Trade Area, that is AFTA. ARICO was established under the Lusaka Agreement of 1976. The AFTA agreement actually is basically one of the benefits or one of the focus of AFTA is to ensure cross-border operation on intellectual property rights in Africa. It aims at accelerating Africa's trading position in the global market by strengthening Africa's common voice and policy space in global trade negotiations. So another body that we have is the International Covenant. Okay, another one we have is the International Covenant on Economic, Social, and Cultural Rights. So I was saying the last time that we have the treaties, we have the law. So I'm trying to discuss the laws on the international background. So yes, the ISDS. Sorry, let me use my PowerPoint. So this is too small. Okay, the ICSR is also a multilateral treaty adopted by the United Nations. It's actually an international human rights agreement promoting the principle of progressive realization of all economic, social, and cultural rights by states to their people. So, as we have said before, intellectual property rights is also one of human rights. So, ICSR also comes in line when we are talking about intellectual property rights. Then the most famous one is the TRIPS agreement. TRIPS agreement is not just about Africa; it's a world agreement by members of the World Trade Organization. In fact, it said that it is the only agreement that first talk about the enforcement of intellectual property rights. It is a minimum standard agreement that allows members to provide more extensive protection of intellectual property if they so wish. The agreement was formally formalized in 1994 and came into effect in 1995. The truce agreement basically just provides a kind of minimal, let me say the minimum standard for countries to adopt when it comes to intellectual property. So it gives them a kind of guide. Even though countries can go beyond that, it provides that okay, it can't go beyond this. Apart from that, we have the enforcement of intellectual property rights in Nigeria. So yeah, it's Section 251, sub 1, sub of the Constitution of the Federal Republic of Nigeria, vested the federal courts with exclusive power to adjudicate in any matter that relates to intellectual property rights. In verbatim, it provides that notwithstanding anything to the contrary contained in this Constitution, the federal courts shall have an exclusive jurisdiction to the exclusion of any other court in civil causes and matter. Any federal enactments relating to copyright, patents, designs, trademarks, and passing of industrial designs and merchandise marks, business name, commercial and industry. So basically, it provides that it gives the federal court exclusive jurisdiction over the enforcement of intellectual property rights, maybe on trademark, patent, designs, and co. Next slide, please. Next slide. So for example, Section 46 of the Copyright Act. Okay. Section 46 of the Copyright Act, Section 7 of the Trademark Act, Section 2 of the Nigerian Patent and Designs Act. All these provisions provide for also gives the federal court exclusive rights to determine on matters relating to specific intellectual properties. Then we have the Article 42 of the truce agreement give credence to the procedure of enforcement.
Hello, Nifemi.
Nigeria is not left behind when it comes to enforcement of intellectual property rights. It is pertinent that civil procedure comes in through the door of national justice. Simply put, the aggrieved party must first have legal standing in courts. Afterwards, he or she shall serve. I think basically this one is talking about the procedure of enforcement, bringing an action in court and then serving the other parties, having a legal representation to enforce the legal rights. And then, okay, so when it comes to enforcement, at least when you try to enforce intellectual property rights, you are entitled to some remedy. The remedy for enforcement, it can include order for inspection and seizure. It can be award of damages. It can be delivery up of the infringed articles back to the owner.
Hello, Nifemi, can you hear me?
Yes, sir.
All right, please kindly round up now. Thank you.
Okay. So it can be right to information. So there are some case studies that we have. For example, in the case of NCC in Wally Sunday, the defendant in the defendant in the case was convicted for book piracy and sentenced to a fine of 300 naira. Also in NCC and Technical System Nigeria, the defendant in that case was also convicted for software infringement and sentenced to a fine of 3,200. We have the other case too, where the defendant was sentenced to 100 naira fine, or 3 months imprisonment. So in conclusion, we said that
hello, Nifemi.
Intellectual property rights. It is the enforcement of intellectual property rights is actually the main thing for the existence. Without the enforcement, then there is no rights. So most business also, it is certainly an option, but given the complexity of intellectual property law, the significant consequence of making a mistake and failing to protect your IP rights, most businesses opt to work with lawyers on IP prosecution and defense matters. Whereas I said earlier, this comes in enforcing the intellectual property rights is actually one of the basic roles of intellectual property practitioners and one of the duty to the claims. So without the enforcement, then there is no right. Thank you.
Okay, thank you so much. Thank you. So we have the final group now to present. Are you ready? So you may stop sharing your screen so that the next group can continue. Thank you.
Comments, they will reply now.
Okay, so it's presenting for you. We are waiting.
Hello, sir. Can anyone hear me? This
Okay, since he's having network issues, is
no,
it possible for someone else in the group to make the presentation on his behalf for the group?
Mark, can you hear me, Mom? Can anyone hear me?
Yes, we can hear you now.
This is from group 1. I'm so sorry. The network here is too bad, Mark. Very bad. So today we're talking about IP registration. Can anyone hear me now?
Yes, we can hear you. Thank you.
So we're talking about IP registration. So we have 2 facets of the topic is like divided into 2. Like you have IP and IP registration. And before I begin the presentation, I would like to lay the foundation that if you talk about intellectual property, we talk about the benefits of intellectual property. We talk about how it can be influential and have a major relevance in business, in whatever undertaking we enter in. We have to find out that we have to identify that before we get the protection we seek, before we have that legal backing, before we have that umbrella of the law to help protect our intellectual property, most times the IP assets need to be registered. And this registration most times is not like a prerequisite for every intellectual property asset, but most times for an intellectual property to be protected, it has to be registered. So in our first slide, we talked about what intellectual property is. We explained what intellectual property is, and I think ever since the presentation, we have been defining intellectual properties as creations of the human mind or intangible creations of human intellect and what have you. But this is not like the focus of our presentation because we are moving to the IP registration in itself. So we talk about the importance of IP registration. So the slide states that IP protection or registration provides the owners of industrial design, copyright, patent, trademarks, geographical indications, utility models, a monopoly over an invention or an original work for a specific period of time. That's all right, because the importance of IP registration is basically granting exclusive right over an IP asset to the owner, as well as having a bit of legal backing from the law, like a legal backing, like protecting this asset. So, for instance, before a company is recognized as legally to operate in a jurisdiction, it has to be registered under CAC. Same with intellectual property assets, where for it to get protection for your IP asset to be protected, it needs to be registered under the respective bodies that are charged with administering registration of intellectual property assets, like intellectual property itself. So they continue by saying, okay, so the slide goes ahead to restrict the importance of IP registration to different intellectual property rights like trademarks, copyrights, and every other IP asset. So, for example, trademark registration dissuades others from using a particular trademark, and the trademark owner acquires ownership of trademark upon registration, and this decreases the likelihood of another party claiming that trademark was infringed upon. So this is trying to say that as a trademark owner, registering your trademark gives it a bit of distinctiveness, one, exclusivity, and protects your intellectual property, your trademark per se, from things like trademark infringement, free riding, different activity that tramples up your trademark. I remember for a brand, your trademark is almost every important thing you should guard, because it helps to distinguish your product from another and helps in your competitive strategy or brand strategy. It helps in your promotional strategy. It helps in every activity your business wants to undertake. So trademark registration is just helps to register, makes that your trademark come into the cloak of protection and says, hey, this is already registered, or you don't need to, if you infringe upon this, you have to face the wrath of the law. And I can come against you in the court or in any proceedings, be it ADR, and get, payment as damages. So without this registration, a trademark owner can't benefit from this benefits as having registered your trademark. So we continue by saying that steps to take to effectively register an IP. So registering different IP has their different modes of registration, but it's important to distinguish protection for by virtue of your copyrighted work being and fixed, you can protection before it is ready. Some case laws, some will I say regulations as well as norms have said that it is better that the copyright is registered, because for it to be distinguished, for notice to be given to other users that this work has been copyrighted. Then we talked about definition of copyright, creation of an exclusive right granted to creators of original works to reproduce, modify, distribute, perform his work. So this is not really the foundation of the presentation. The crux of the presentation is saying how this right can be registered effectively and the steps on registering this IP rights. Now we went ahead to talk about requirement for copyright registration in Nigeria. Now, as I already stated, it's not a prerequisite for your copyrighted work which is subject to copyright protection to be registered for it to be protected. However, it is stated that for effective protection, that's just better that you register your copyright, your work, to enjoy copyright protection, maybe from the Copyright Commission. So if you want to toe the line of registering formally, there are things required of you. For instance, the particulars of work being registered, owner's name, address, telephone number, email address, the type of work, title of work, year of publication, the country of publication, year of creation, and many more. You see particulars of author, first name, last name, and everything. Now, when we continue, talk about, in contrast, and this is prerequisite for the protection of IP. US copyright law protects original works of authorship fixed in a tangible medium, including literary, musical, dramatic, pantomimes, and choreographic works. So this is trying to say that in the Nigerian context, registration is not really like a prerequisite, but most jurisdictions have modified this requirement by saying that, hey, you must register your copyright for you to enjoy protection. Let's make it more formal. But if you compare and contrast, you see that in the Nigerian context, an owner of a copyrighted work needs not to register his work to enjoy protection per se, but he can step higher to formally register his copyrighted work. So he can actually fly and sue others if his work is not USA. You have to register trademarks, right? So this lays a proper foundation of what trademarks are, the laws governing trademarks like the Trademarks Act and other authorities that govern trademark registration. Now, in Nigeria, the first stage in trademark registration is to conduct a search. Now, for example, if you spotted if you're about to register a trademark or whatever, mark, design, industrial design, patent, GI, or whatever, you have to do like a trademark search. It's just like a due diligence in whatever transaction, be it an M&A or whatever transaction, you have to do your due diligence. Same with IP. You have to do your trademark search to say, oh, this mark, yes, it's distinctive. Yes, it is not generic. It is beautiful. But is it similar? Has anyone used this mark? Has anyone appropriated this mark in its product as a trademark? Then you do your trademark search as a preliminary due diligence to ensure that, okay, you don't have anyone giving you an opposition letter that, hey, you shouldn't do this, you shouldn't trademark this because I've used it, or it is, it's already used, or is a well-known in another product or something, or maybe it infringes the culture or whatever requirement that's required that a trademark owner who wants to register his trademark ought to have met. Now, we'll talk about after the search, it is done that it is done after the search is done, the trademark can be filed, but it should be examined to check if it is registrable. Like I said, if found to be it shall be registered, and the requirement includes words, logos, and different types of trade name, applicant's email, phone number, and what have you.
Hello, Anthony.
Let's
Please, you can
take
start
this like
from
much more, tractly. Unless a trademark is is registered, its owner will not be entitled to institute an action for infringement. Like I said, registration gives you that legal protection from the law and gives like an umbrella where you can be able to sue, recover damages, get accounts for profits, or get a bit of redress, yes, if your trademark is being infringed upon. Then, for the sake of time, we talk about, we examine different modes of registration. You have the national framework, regional framework, and the international framework. Like for trademarks, you have this framework, you have different laws guiding registration of IP rights in the regional framework. Regional, I mean Africa, East Africa, or whatever. Then we go ahead to this. We'll go ahead to the case studies where we saw different brands and entities who failed to register their trademarks and the result of that. So in 2019, Nike claimed that Adidas had infringed their patent, thus they told the US Trade Commission to block the import of Adidas shoes as it infringed on patent covering their flying shoes. However, Adidas was able to invalidate the peanuts infringement slammed on it by Nike. This is because the mark the patent was not, I think it was not legally registered, and given by, wasn't really recognized as a patent. Now, you have different case laws talking about the importance of registration for that register. However, like I said, copyright, you can enjoy protection for copyright if not registered. So to finalize this, I would say that the importance of IP registration is more emphasized because as an IP owner, be it a creative, a business owner, you have to approach the authorities, those who are giving you have the right to register your IP to gain protection. If not, your IP will open to different floodgates of infringement and will not have any force of law, subject to the fact that some IP rights you must not enjoy, but it's better if you go ahead to register your IP so that you can have the force of law in case of any infringement. Thank you.
Thank you. Thank you very much, Anthony. Thank you. Every other person that's presented for their groups, thank you. So I'm not sure if I should apologize for the network because I'm not the cause, but it's a pity that we have to deal with the network issues here. So I'll just go ahead to read out the profiles of our mentors, and then we'll listen to them to get like the practical aspect of what we are all talking about. Okay, please hold on. Okay. Sorry, I'm using my phone because. Okay, so our first mentor for today is Rita Anwiri Chinda. She's an intellectual property and information technology lawyer from Nigeria. In September 2021, she was listed as a leading Nigerian woman in business law by Esquire Legal Practice magazine. She won the 2021 Young Legal Professional YLP Award of Excellence and was listed as one of the 2020 WIPR Influential Women in IP Trailblazer. She provides advisory, advocacy, and transactional legal services to a broad spectrum of local and foreign clients. She has cognate experience in projects concerning data protection and privacy, media law, copyrights, trademarks, and patents. Rita holds a master's in intellectual property and information technology from the University of Derby, UK. She's a member of the Nigerian Bar Association section on Business Law Committee on Arbitration and Alternative Dispute Resolution, Information and Communications Technology and Intellectual Property, member of National Institute of Management and associate member of the Chartered Institute of Arbitrators, UK, Nigeria branch, current PRO of the Port Harcourt chapter and the pro tem secretary of the Young Members Group, the PRO of Nigerian Bar Association Young Lawyers Forum, Port Harcourt branch. Rita is also a co-contributor to the 6th edition of the International Comparative Legal Guide on Data Protection 2019 and published an article with the Trademark Lawyer magazine titled How Artists Can Commercialize and Exploit Their Intellectual Property. She has a podcast series on Anchor, which is also distributed on Spotify, Google Podcast, Apple Podcast, Radio. Please, can you mute yourself? Someone is speaking and is not muted. Okay, with a Twitter series where she talks about intellectual property and a blog post on Subtracks. She also has a group for lawyers called Building a Community, who meets weekly to network and have conversations on various topics ranging from career, relationship to things happening globally, and also a group called IP Hub for intellectual property enthusiasts. She's a member of CIARB YMG Global Steering Committee and a recipient of the Esquire 40 Under 40 Rising Star 2021 Award. She's also the chief convener of the Intellectual Property Society of Nigeria, IPSN. In her spare time, Rita enjoys traveling, listening to music, watching movies and series, especially South Korean movies and tutorials. Okay, I'll just quickly go ahead to read the profile of our second mentor for today. Our second mentor for today is our second mentor for today is Sheyi Arowo Sebe. Sheyi Arowo Sebe holds a master's degree in intellectual property law and policy. He is the principal partner at Deluxe Consult. He's an alumnus of the Lagos Business School, University of Ado-Ekiti, Nasarawa State University, and Nero, USA. Called to the Nigerian Bar in 2014, Sheyi started his professional career as a lawyer in the law firm of J.S. Okutepa San and Company, where he was exposed to litigation in all superior courts in Nigeria. He was also an associate in the law firm of Dapo Owo Ade and Co., a corporate and commercial law firm. In 2017, Sheyi established Deluxe Consult, a corporate and intellectual property law firm which has helped hundreds of clients in the formation and maintenance of corporate entities and also safeguarding the copyrights, trademark, patents, and design of individual and corporate entities. Sheyi is a consultant and Citizens Gavel, a civic tech organization accelerating engagement. Among her other programs, Gavel offers pro bono legal services to indigent persons, victims of all forms of abuse and brutalities, and awaiting trial inmates in various correctional centers across the country. Is a legal advisor to the Fellowship Abuja initiative, a gathering of young Christian professionals, entrepreneurs, and creatives. He is also the legal secretary of Every Child is a Star, a non-profit that caters for the welfare and well-being of underprivileged children in society. She is happily married to Oye Binte, and they are based in Abuja, Nigeria. So we'll just quickly hear from Rita, and then we'll also hear from Sheyi on their practical experience on these topics. You're welcome, Rita. Please let me know if you can hear me. I'm calling on Rita to join us if she's here. Okay, if she's not with us, then we can hear from Sheyi.
All right, thank you so much for having me, and thank you, Juliana. I want to appreciate every group who have presented today. You guys have done a lot of work in assessing IP from the various quarters. Please pardon the background voice you may be hearing from this conversation. I'm completely out of jurisdiction as I speak with you. I'm in Gombe State, a new territory entirely. So, but just please try and concentrate on the few things I'll share. You guys have actually opened up on the issues that we should know about IP. In fact, I'm just looking forward to the questions that you may have right now. Establish some foundation about IP, the need for protection. But beyond the legal rights, beyond the legal protection that the law gives to IP, be it trademarks, be it copyright and the like, there is the moral angle to it. You know, beyond the law supporting the owner of the work to enjoy the economic benefits accruing from that work, there is the moral angle to it. So, for instance, when I wrote a book and published a book, beyond making economic gain from that book, I have some moral rights on that book. You know, the right to be acknowledged as the author of that book remains with me perpetually. You can't take it from me. You know? The right to permit anybody to adapt, you know, to convert it to other forms of IP remains within me. You can't just pick my book up today and then you say you go and write a stage play on it without consulting me. You cannot convert my book into a movie without consulting me. So these are some of the rights that we should also focus our mind on. And then when we discuss IP, I would always, you know, like us to give some practical and domestic examples. For instance, I love copyright so much. It's something that every one of us do. You know, for each of the slides you guys have prepared for this conversation, there is copyright in them. And I don't know if you know, because the basics of copyright protection is that you've been able to put your thoughts, your ideas in a codified content, in a form that you can see, that you can put. So you have fixed it into that PowerPoint presentation. You can go on Facebook and drop a few lines straight from your head and publish on Facebook. You enjoy copyright protection. The presenter for group, I think group 3 now, Anthony, he rightly mentioned that you do not necessarily need to go to Copyright Commission to register your work before you enjoy protection for your copyright work. You know, however, the only reason you would need that registration is perhaps when it is time to now approach the courts. You know, to now perhaps sue an infringer, or you want to go to ADR now. Will now ask you, so where is your proof of registration? How, even without that registration, the moment your work is published in a medium that you can see, you know, you either publish it in a book that is hard copy, or you publish online in any of the platforms where copyright works can be accessed, either for a fee or for free. you have done the needful, you have fixed it in a medium that you can see. And then beyond that, for you to enjoy copyright protection, there's what we call consanguinity. The author has to have something to do with Nigeria. So one of the co-authors or all must either be a native of Nigeria or the work must have been done here. So you must have a link with the country before you can enjoy copyright protection for your work that you've done in Nigeria. There was something that was not mentioned as regards trademark. It is important that you register your trademark for you to enjoy the legal rights that follow trademark protection. However, when you don't register your trademark, the rights you would enjoy in law is called personal. So it is more of an equitable right that accrues to trademark owners. So you don't ever lose out of your work. The moment your work is done, is produced, is put out there, there is a protection that the law automatically gives to it. This applies to copyrights, applies to trademark in the name of personal. Taking it further now, when we talk about patents, it is important that you register your patent at the registry. The protection that you get when you do your patent is 20 years, 20 straight years uninterrupted protection. And at the end of these 20 years, it lapses and it goes back to the public domain. But there are things you can do to activate another 20 years. When you take that work and then you're able to put in another inventive process. Of course, I want us to know that the patent in Apple product today, 20 years will have elapsed from the first registration. So what they need to do is to come up with, okay, now we have iPhone 13. Okay, so when iPhone 14 comes, the patent on iPhone 14 starts counting for another 20 years. Before the 20 years even finishes, we already have another iPhone out there. So then I also expect that there will be a touch of comparison between these 4 forms of IP: copyright, to trademark, to patent, to industrial designs, because the protection that the law gives each of these 4 are different. Okay, so whereas copyrights, which is I like to call it the simplest form of IP. Permit me to use that word, but you may not agree with. Like I said, when you write something and you publish anywhere on the media, online, there is protection for that work. And then you enjoy copyright protection 70 years after the end of the year in which the author dies. So when you publish a work of copyright, you're entitled to protection of 70 years after your own lifetime. So it means a whole generation after you continues to enjoy protection, continue to enjoy the benefit that accrue to that work. Okay, so that is for copyright. For trademark, the first set of protection you enjoy after registration is 7 years, and then you're entitled to a renewal of 14 years subsequently ad infinitum, because we do not expect that the brand image you have created for yourself can expire. Somebody else can take it. It belongs to you forever. But you owe a duty in law to continue to renew that registration. If you fail to renew, the Registrar of Trademarks can actually cancel your registration. For patent, I've mentioned earlier that protection is 20 years and it is not renewable. And the reason is actually simple. Okay, patent is protected for 20 years, and the law gives room for healthy competition. So if in 20 years you're not able to come up with a better way of doing that invention, then somebody else can come up with a better way of making that machine, making that invention in a way that is better than what you have done. But it's totally new, genuinely new, and it is not seen anywhere. So in 20 years, it's expected that you would have gone back to your research, to the factory, and carve out something new. We didn't talk deeply on our presentations about legislation, litigation rather. Before we arrive at litigation, it's expected that when you observe that somebody is infringing on your work, it's expected that you start with a gentleman's approach by perhaps writing a letter of cease and desist. Perhaps you see somebody putting your logo, your image on their product and selling as if it was you that was doing that. This could harm your net worth, it could harm your image, it could harm everything that pertains to you. So there is need for you to first of all approach them from the gentleman's approach. Hey guys, you need to stop doing this, you know. So of course, when they fail to do that, you have all it takes to either activate the ADR mechanism or go straight to court. But then going to ADR would to me would sound as though you have a persistent contract, a persistent agreement with the person you're dragging to ADR. Most times we just find ourselves in court and perhaps somebody, perhaps the court advises, or a party just requests that we try and settle out of court, perhaps through arbitration, mediation, conciliation, or even negotiation. Okay, so let me jump the gun now and talk about the duties of legal practitioners or professionals as well in the whole process of IP. You can't just underestimate what professionals can do to enforce the IP rights of people, of owners. For instance, patent has been infringed. How do a lay person go about enforcing the rights in that patent? You just want to go to the court and say, my right has been infringed and I want justice? No. I was in court about two weeks ago and I saw a landlord making a mess of himself. The landlord was in court with his tenant. His tenant has a lawyer right there in court, but the landlord felt he could DIY. Okay, he came to court and he was trying to ask the tenant now, who is the defendant, question. I shook my head throughout the time I spent in that court. I had a headache. You don't need to spend so much money to engage with a lawyer, really, but people just feel that once you are calling a lawyer to wade into a situation, it costs so much money. It doesn't cost so much money if you know what to do. If you involve a lawyer right on time from the onset of your business, it will help. We have clients who pay us, I call it maintenance money monthly to service that are brief. You know why? Those ones are smart enough. They involve you from the beginning. So you need to engage lawyers even from the onset of your business. Of course, as from registration to the guidelines to the to compliance, you need lawyers to be in the picture. So get lawyers involved from the onset before the business grows big. So if you want to grow big before you engage lawyers in your business, you're just telling us to come and cash out when you are big. But if you are humble enough to bring us in, to bring lawyers in at right from the beginning, the advice you get from that onset has a way of putting you on track. Before you take any step, you involve the lawyer. So the need to involve lawyers to enforce IP rights cannot be overemphasized. It is these people who have the technical know-how, the technical expertise at helping you to enforce the right, perhaps ask for damages, write letters and desist, of course, file actions in court. And then there are times you need to grant licenses, there are times you need to enter agreements on people to use your work for a fee. You need the guidance of legal practitioners to wade in and then help you through the process of this. I will just stop here now so that we can entertain one or two questions. And I also understand that Rita ought to be on this call at this time. So thank you so much, Juliana. I look forward to
Thank you so much for the advice. And I think what you said is very valuable when people think that lawyers are very expensive, but it's good that you spoke about getting a lawyer from the beginning. It would help. However, it would actually help. And lawyers can be expensive anyway, but you just have to count your cost and do what is best for your business. So let's hear from Rita. Hi, Rita. You're muted.
Hi,
okay. Thank you so much.
Can you hear me?
Yes.
Yes. What exactly am I talking about? I think at some point I dropped out of the conversation. Do you hear me?
So I didn't hear some parts because you broke at some point.
So I would say, what am I supposed to talk about? Because I think I lost the conversation at some point. Am I
Okay.
like a general overview of what?
Okay, yeah. So you're supposed to make comments on the presentations that were made from your practical experience. So I know that you're into IP and you're also into consulting and into alternative dispute resolution. So you will be giving comments based on your practice on how to register, how to enforce where there's infringement and or alternative dispute resolution in respect of intellectual property rights.
Okay, then fantastic. Okay, first of all, great job, everyone. I went through. I know Juliana shared your presentation with me, and you guys did the best you could based on your knowledge and expertise at this moment. Even for me as a practitioner, I'm still learning on the job because you find out that with every case you get to have a strategy as to how you're going to actually follow it. So I'm going to start from IP registration, which is what I think most IP practitioners in Nigeria focus on, forgetting that IP registration is just like the tip of the iceberg when it comes to IP. You also have the building of the portfolio, you also have the commercialization aspect of the property. You're going negotiating prime deals, you're negotiating licenses, you also find out IP strategy as to how they can exist or extend the term of relation you each of the IPs have. So let's take copyright for instance. Copyright is liberation for 70 years after. And then in Nigeria, because we don't apply, we don't necessarily register copyright, but you have to deposit a copy with the Nigerian Copyright Commission through their e-registration portal. And then you have instances where I'm not buying the idea of why I necessarily need to register my IP. So you are doing the work in terms of educating your clients, why trying to get them to, buy into your conversation as to why registering an IP in Nigeria gives you some legal backing. So most times I get conversations or I get questions about how someone wants to do an international IP registration. And then they ask the question as to which of the territories or countries they're looking at, and then they get upset. So we have about 7 continents and how many countries in the world. So you have to pick and choose where you want, because IP protection is territorial in nature. So it's the countries that you register your IP that gives you right. So I'll use photography, which is a type of copyright, for example, search of that now. So in Nigeria, we've had instances where people's image have been. Can you hear me?
Yes, we can hear you.
Great. So you have instances where people's images have been used for commercial purpose, or so let's use a regular advert now on your street, a papa's shop. See a photograph of a celebrity with a particular hairstyle or haircut, and you go in there and you say, can you make this for me? The person says yes. So now what that does to your mind or gives you the impression that this person's image there means they are either linked to that person or can actually do what this person actually has on his or her body. Then you have instances where let's use the entertainment sector, the musical works, for instance, where you have artists who basically don't have an idea of what copyright is, don't even have an idea of what should be in their terms of agreement. So you're trying to educate someone whose main goal is to blow or be signed to a record label, and you're trying to tell the person to have it, because when you are at the negotiation stage in terms of negotiating your contract with the record label, you have to have something because it's give and take. The record label is basically investing in you at the end of the day, and then all you have is just your musical talent. But if you create a profile, you build your fan base, have data in the digital space out there, that gives you an edge when you're negotiating in terms of your percentage and royalties and rest. So the next part is the trademark. Everything, I feel like everything can be done. So if we follow the cases within the last year between NBC, so we have the fearless predictor case, and we also have the Coca-Cola case. And you notice that one thing that has stood out is logos and names of these products themselves. Then when you want to do the actual registration, I know one of the, I think it was Anthony, one of the presenters gave a brief outline of how you do a trademark registration where you have to start with research. So other than going to register to your own, you can also do your own due diligence by doing a Google search. That saves you time. Then have a discussion with your lawyers. Like Jen mentioned, it's very important that you have a lawyer or your retainer, not just any lawyer, a lawyer that's versed in intellectual property. So what I've noticed or seen in the international space that you have IP lawyers who are practitioners, but also specialize in the types of IP that we have. So you have the trademark lawyers, have the copyright lawyers, inside the copyright lawyers, have people who are versed in entertainment sector, you have people who are versed in the film industry. You also have people who are versed in the broadcasting and sound recording, and everyone is specialized. But what we do here in Nigeria is basically we just generalize all our practice without putting that into consideration. Now, back to the case I mentioned. When it comes to IP dispute, the law says Federal High Court has jurisdiction. Now, we've had this conversation where someone has argued that unregistered trademark should not be resolved at the Federal High Court or at the High Court, but that's debatable because you already have the possibility to just Federal High Court. So why would you want? Because an unregistered mark is still an IP. The only thing is that an unregistered mark does not have the full backing, just has a limited sort of IP protection at the end of the day. Then you also have to make out, okay, another thing I need to point out with regards to these cases is the fact that I feel, this is my own personal thoughts, I feel like Nigerians are not creative when it comes to names. So I went to More yesterday, and someone walked up to me and said, do you want XYZ? And I said, no. Of their brand, and it has HFC. So you have KFC and you have HFC. That's going to cause some sort of confusion, or can cause that to be a passing off at the end of the day. Because one, you are not thinking about you basically don't have a long-term goal for your business, which is why you're not creative enough about your name, your logo, your sign. So I was involved in an event last year where someone accused the organizers of infringing on the designs and their logo. So those issues it might seem inconsequential, but they're very in the international space, it's a very big issue. Now I also move to patent. Now when it comes to patent, there is something that we need to take note of. So if your invention is new in Nigeria, do you think that your invention, if you decide to protect it in another territory, would be new in that country? So a few years back, I used to work at a firm, and we had this client who came with very brilliant idea. When we did a Google search, we found that his invention was located in another territory. Now the question was, what makes his own invention different from the other people's invention? What is something that qualifies or makes it new and novel? Because those are like the basic elements when it comes to patent protection in Nigeria. It has to be new and novel. It also has to, it doesn't have to be obvious to a skilled person who is in that same line of business. So those are the things I need to consider. That's a question you need to also consider. You also have to read your section 1 of the Patent Act to know what's actually required. So one thing I like to tell lawyers that reach out to me and make inquiry when it comes to IP registration is, first of all, you need to go to the basics. Know your IP law. What does it say when it comes to criteria for IP protection, be it a copyright, patent, trademark, or design? Now we have the plant variety. I don't know how many of you have looked at that. I don't think anyone mentioned this, which is kind of upsetting and disappointing. But if you did not know about this, check out the Plant Variety Protection Act, which was assented to last year May. Then the next IP I will be talking about in terms of IP registration is design. So design, basically a combination of line colors, must be new and the rest of them. So you have like a similar criteria or requirement for protection. However, what the law says is, if you've been using your design for the last 6 months, you've not registered your design, and you decide to go ahead and do a registration, you're giving that 6 months grace to go and do the needful. Failure to do that means we lose the right. So I don't know if we are aware of Diola Sage. A few years back, she did a design right protection for her famous Kumole Ashoke line, and she put out a notice out there saying my design has now been registered with design registry. Anyone who decides to use my design will be, definitely hear from her lawyers at the end of the day. So IP registrations for this so then again, for the Plant Variety Act, the requirement is it must be new novel and be in uniformity. I can't remember the last one. But then you also have to go back to this criteria when you're doing your IP registration. Now you hear people say you don't have laws or you don't have enforcement when it comes to IP. That's not true. People always want to leave things to God. So if you notice during the pandemic, there were a lot of social media call-outs in terms of IP related dispute, and people were like, "Oh, the court's not going to do anything for you, no one's going to come to your." But then you forget that there's like a whole security personnel who the court might order to go do an injunction or a search. At the end of the day, you have the police, you have the customs, who are also supposed to be on the lookout for counterfeit. I know the Nigerian Copyright Commission once in a while do a raid where they go ahead to look for pirated books, CDs, and the rest of them. So we have all of those enforcement agencies there, but how are we utilizing them at the end of it? That's the question for us to answer. So if you have someone reach out to you and say, there's this person that has been on my right, so that the remedies are available to me. One of the remedies is getting an injunction. First, you have to do a cease and desist letter. So it's the purpose of a C and D letter is basically to tell the infringer or the third party using your work without your consent, your permission, or authorization to stop using your work without your permission. Then when the person doesn't, so you have to give person a timeline. And as an arbitrator or as a dispute resolution practitioner, timelines are very important because it guides or gives you, it basically gives you a timeline as to how your dispute will be resolved. So let's say we have a contract, a licensing agreement, and in your dispute resolution clause stated there that you have to, in the event of a dispute, you can explore negotiation within 7 days. So negotiation is not something it's something we do, but we don't consider it to be a form of dispute resolution because it's not binding. So when you say we are going to negotiate, so let's say someone breached a contract of licensing deal or whatever technology transfer deal, whatever the agreement might be, and you want to renegotiate a particular clause, that's where your negotiation skills comes into place. Tell me what you want, I tell you what you want. At the end of the day, we have to meet in the middle. Where that doesn't work within that 7 days period, we're not giving 21 days to and date. Mediation is also not binding, but then or a huge have been finding for years about the US or the what the US I think that get that point because I think we want to score these different for products that meet the market and so register conference about 8 weeks. Then you also have to apologize. Can you hear me now? Can you hear me now?
Yes, I can hear you. Just like briefly.
So I'm talking about the when you are you like
You're still breaking on my end. I'm not sure. Can the rest of you hear properly?
It's same here. It's breaking.
Okay.
It's also breaking on my end.
An arrangement. Is it still not clear now?
It's clearer now. When you said
Okay.
it's not.
Okay, great. So let's say Samsung and then Apple Inc. wants to go into say Apple needs a gadget or an invention from Samsung and they go into an arrangement and it's worth say $300 million. That's a serious commercial transaction. So you're going to be thinking big. Arbitration will be your first point of call. Now in Nigeria or generally said, where you don't specify the number of arbitrators that should sit on that panel, it's assumed that it's going to be a 3-man panel. So in arbitration, you have instances where you see a badly drafted agreement or an arbitration agreement where it says in the event of any dispute, so you make it an ambiguous clause in the event of any dispute. But if you're specific that in the event of XYZ dispute where part A or part B does this, that streamlines the dispute at the end of the day, and then you don't have to end up spending so much. So I always tell people that I don't think arbitration is expensive. I just feel that because your claim determines what the panel is going to charge. So I've been on a panel where the claim was 10 million, and we had a 3-man panel, and then we had a senior, let's say someone who is a fellow at the Institute of Arbitrators. The scale of schedule sometimes they have the panel use schedule of fees of the institute, or they decide to just give you a random figure based on your claim. So you have a 10 million naira claim. What would the arbitrators charge? I've also been in a panel as a registrar where the arbitrators, the fee wasn't so much, but the arbitrators were lenient enough to consider that the main purpose of why they were there was to help the parties resolve the dispute. And they ended up accepting whatever the parties offered them because it's an informal. So the arbitrators want to basically just listen to you and tell you or make you know that one of the benefits of arbitration is flexible, it's not expensive, and that's my own view. But coming to intellectual property, where you have franchising disputes and the rest of them, I think your best bet would be to start with negotiation and move to mediation before considering arbitration. It's not a serious deal. Then you have instances where you don't even have a dispute resolution clause, a dispute resolution clause in your agreement. So you have what's called a submission agreement where you decide to resolve your dispute through any of the ADR mechanisms. Then you have the Federal High Court, which is like for litigation, concessions matters, and the rest of them. So sometimes we need litigation sector to do their job in terms of setting precedents. So I did mention disputes on photographs. So last year we had, I don't know how many of you have seen it, but binary cases, a case that I felt the court should have set a precedent, in relation to image rights in Nigeria, because we basically don't have like a strong precedent as to what the court says or view when it comes to protection of image rights as an individual, not now as a celebrity. In the United States, you see celebrities are fighting the photographers or paparazzis who are suing celebrities left, right, center. Recently, Kanye West came out to say he believes there should be any royalties from those pictures because one, I'm the subject matter in that picture, but what does the law say? The law says whoever takes the picture owns the copyright at the end of the day. Then, I know Juliana sent me a question as to timeline when it comes to, IP disputes. I think there's like an unspoken rule when it comes to IP infringement. Once you know there's an infringement, it's best to go to court immediately. You don't have to wait so long. But I think one case that came to my mind when she sent in the question was the Nirvana case about the boy who was used on the cover picture or cover artwork for a musical band, and then he comes 30 years later suing them for privacy because I think he was wearing a Pampers or something. But to him, he felt he was half naked. So that was a very controversial space in the international space. In Nigeria, we don't have such interesting cases where people want to test the law to see what the law has to say. For timeline, I think it depends on the type of IP. It also depends on the the work in question basically. So if it's a musical work, if it's a photographic work, if it's sound recording, if it's an invention, if it's a trademark. But I noticed that with every IP case that I've seen and I've read about, for once the IP owner notices that there's an infringement, they go straight to court or they sell or send out a cease and desist letter. But then again, you have instances where you are not in that territory, but then you are made aware that your IP has been infringed in another country. What do you do in that instance? Do you trigger an international treaty at that point, or do you go ahead to look for a lawyer in that country to help you resolve your dispute? Which is where the WIPO Arbitration and Mediation Center come into place. Where and that's a very good place to start if you're looking for IP related issues. That they have like a whole catalog of IP dispute on any topic that you want to make your inquiries about. If the IP dispute was a contractual agreement, basically, I think the minimum or the maximum is 6 years for those type of cases. Then what else? Then as a practitioner, I think what I normally tell my mentees or colleagues or anyone who asks me a question when it comes to IP, if you want to go into IP in Nigeria is still growing. So the reason why I chose to do IP or chose IP as my area of specialty was one, other than the fact that I did it as an elective course in my undergraduate, I also wanted to do something that was different and not popular. So which was why when it was time for me to do my master's, I chose IP, and then I saw that there was a mixture of IP and IT. So they have the IT aspect of intellectual property focuses on data protection, cross-border disputes, media laws, sexual offenses when it has to do with child pornography or the internet, to children whose images or pictures or works on the internet. What are the laws? Because I don't think we have such laws here in Nigeria. I mean, like I said, I'm still learning and I'm still reading, but then IP is interesting now there. But when it comes to Nigeria, everybody's just focused on the IP registration aspect. Then in terms of fees, statutory fees are always low, but how you make the money as a lawyer is when you gauge your value and your worth. And then you also have to think about your professional services, because you're a professional. So I've had instances where someone found me on LinkedIn and then he sent me a message as to, we have this product we want to put in the market and want to patent it. And I go, okay, here's my email, send me a formal email and I'll send you my invoice for consultation. And he says, okay, and then goes ahead, send me the email with 7 questions attached to that email. And I told him, okay, these are my rates for, if you want an opinion, this is my rate. If you want to talk to me, these are my rates per so for 30 minutes is what I charge, for 1 hour this is what I charge. And he goes, keeps me on mute, doesn't respond to my email, and then comes back a month or 2 later telling me, oh, those questions we asked you, that you asked us to pay you for, we finally found an answer. And I was like, good for you, but then you're talking to a professional. You're not going to talk to me for free. So I need you to get that into you. Well, this wasn't how I said it, but what I just said was, if you're talking to a professional, you have to pay a professional for their fees. And then he comes back weeks later, oh, we need your assistance with X, Y, Z. And I go, okay, these are my rates. And he paid me 10 minutes conversation. He paid me for that. So as a lawyer or as a law student that wants to branch into IP, be sure that IP is what you really want to do. I also advocate for specialization in IP in Nigeria because that's going to help us develop our laws. I feel a lot of people focus on copyright and trademark, but then we need our patents area to be developed, we need the design right here. So there's also the trademark aspect when it comes to confidential information, non-secondization, the disclosures and the rest of them, where people, so I'm an employee in a company. So I'll give you a live case that concluded, I think, last month. So this month. So that case has lasted in court for about 25 years. The South African case about the, I've talked about it as well. It's called the Please Call Me. So if you know the short form that we use when GSM came into Nigeria. So the actual inventor of Please Call Me is a South African guy that worked for a telecom company called Vodacom. And he did that, created that invention while he was an employee in that company. But when he did that, he went ahead to make a pitch to his company and told them they could license it from me. He told him, and they accepted. But because they saw how he made a lot of money for them, they decided to change their conversation. There was no formal agreement, so that can be debated. But then they decided to change the conversation and the terms of agreement, and like, oh, you're an employee, we're not supposed to pay you this. So if you're an employee in a company and you get your employment letter, please read the IP clause, what it says when it comes to who owns what. So if the company says whatever you paid belongs to me, that means even if you're working outside, you're at home and you're working on something, because you're still employed in that company, whatever you make belongs to the company. It's even worse if the company gives you gadgets like laptops, routers, and the rest of them, and you're using it to create something. So you have, I know I've read somewhere where it says company monitors what their employees do during the work hours. There are certain websites they're not allowed to access and the rest of them. So you have issues that are now overlapping everything that's going on in the company. Then if you were hired to do a job, for instance, you're a developer, you're a graphic designer, you were hired to do a work, and I negotiate a fee with you, but I don't sign a contract with you. What the law says is the product or whatever, the design you did, the software or the website you built or the app you built for me belongs to you. But if we sign a contract stating that you have to transfer everything to me, both economic and moral rights. I know, I think Sheyi mentioned that, and I think one of the persons I mentioned that you do not have this. Sometimes you have commissioners or people who hire people to say, even if you transfer this, you can't put it in your, you can't come out to say, oh, I work for Maven Record or I work for Armory, because that's what I want. But if you negotiate that term and say, okay, even if it was a work for hire, I'm giving you everything, I'm giving you all the economic rights, the moral rights, but please let me put this in my portfolio that I did this job for you. That gives you an edge. And it also tells the person that you're well informed. I know I've had an argument with a developer who was doing a job for a relative of mine. And then this is another aspect I think you guys should take note of. So, you know, the data protection aspect I talking about data of the exchange. So most terms of use or privacy policies that you see online has like an IP clause in it, where you're seeing irrevocable rights in perpetuity. I hate that word in perpetuity because I feel like it kind of takes away control from me to make money from what. So I'm giving you the right, I'm transferring my right, or I'm giving you access to my content, but you want to own my content in perpetuity. I remember I had someone tell me last year, I will come teach on his platform, but my content belongs to him in perpetuity. And I'm like, dude, I'm not signing this. There's no way I'm going to sign this. Either you change this and say for the next 5 years, when the 5 years elapses, you take down my content. But if you're not going to do that, then let's leave it. So you also have to be self-aware as a lawyer. Sometimes you get taken advantage of. So other than being a lawyer, I own a podcast and I own a blog where I write. And these platforms that I use have their terms of use, they also have their requirements. So MTN started off their own podcast, and I attended the flag of last year. Then they said if you're interested, they have your podcast on their show, you know, indicate, and I indicated my interest. And then they sent me a contract that was, I mean, I read the contract and I was having headache, and I was like, what am I actually reading here? Like, I already have my content hosted on a platform, but I want to host on a say Nigeria, it's a South African company, but then it's based in Nigeria. But the conditions you're giving to me as a content creator was not favorable to me. So I refused to sign. And the lady called and I was like, I have issues with your contracts. I mean, it doesn't make sense to me that you just want to take everything from me. And then the royalties you're offering me, I don't know what calculations people use, but I don't think it's not a fair deal for me. Because I make money from Anchor. It's not huge, but how Anchor rewards you is the number of plays you get determines how much you make. For people in the US, they have the opportunity to get like ambassador deals and the rest of it. I can't get that because they've not triggered that requirement in Nigeria. But then a supposed indigenous product in Nigeria wants to take more than half of what I'm supposed to be earning. So I don't see them,
it doesn't work for me. And she's like, okay, just pick what you will not want to be in the contract. And I was like, that's a lot of work for me. And then, but again, I kept getting messages from them, oh, we've launched something on your platform. And then I always make sure that for every platform that I'm going to visit, I take my time. I know it's a lot, but sometimes I skim through your terms and conditions, your privacy. But well, so I know that, okay, if I'm going to sign on this platform, whatever happens there, I'm bound by it. So you also have to be informed as an IP practitioner. Then, how do you educate the consumers or your clients? You create content, you volunteer to speak at events, because in this digital era, your digital print is like your selling point. I tell people I'm more of an introvert than an extrovert, but because of what I do, people see me as an extrovert. So if you really want to make it out there as an IP practitioner, these are things that you need to do yourself. The enforcement is not an issue. I know the UK always publishes what the custom office is doing in relation to fighting piracy and counterfeiting. We do the best we can, but we're not doing so much. So I know when Dora, what's her son name now? The lady with NAFDA, when she was alive, she did a lot of, yes, thank you so much. She did a lot of job in fighting the counterfeiting drugs. But look at it now, you even see people at the back of their house, counterfeiting from food you eat to what you put in your body to everything. So it's like it seems like the laws we have are just there for fancy, and the officials there are just there for fancy. People say Nigeria is a zoo, and I always find that it's not a zoo. We have the responsibility to create that awareness, because it's when you keep talking about it that people will be in the know as to how all of this is work, even when it comes to IP registration. So I've had clients that question me and like, why do I have to pay X, Y, Z? I'm like, dude, my fee includes statutory fee and my professional fee. The reason why you're registering your IP, you don't give them like a generic reason. You have to tell them the benefits. So sometimes I just ask, what's like a long-term goal for your business? Where do you see your business in the next 5 years? Do you intend to expand to another territory? And, you kind of just engage them. So I think that's like one of my biggest deals ever. And I'm doing on tourism, hospitality, and what again? Well, in that sector, which has an IP, and the main point that my client is focusing on is IP. And I don't know how this person found me, but he just found me, and then he just said, I want you to tell me what's the IP aspect of this job. That tells you that person has done his groundwork, but he needs an expert in that field. So you have the big firms out there. So how are you going to compete with those big firms out there who already have the capacity, they have the knowledge, they have the connection? How do you distinguish yourself when the clients come? They're going to say, oh, you have to do your IP so that you get IP protection in Nigeria. Other than that, what else? What other benefits do I get from that? Because I register my work and someone pirate my work or counterfeit my work. I go to court and my case sits in court for 5 to 6 years. I don't know how many people know I think there was the ShopRite case, and the musician who said his jingle was used by ShopRite and he wasn't compensated, and he's been in court for 6 years and he's dying. You're trying to get public sympathy, but if you would persevere, sometimes I feel clients also contribute to what is happening in court. So you're supposed to be in court today and you don't come to court. And then again, I also think lawyers who do not, I think I'm talking to the lawyers, let me just that. So I feel everyone has a hand to play when it comes to making judiciary work, when it comes to IP laws or cases and setting precedent. I also think it would be very important for us to have like a small claims court. I know the US recently created one that hears IP design. I think one of the Asian countries did that after the pandemic. I think this is Nepal too. But we need those platforms that gives those that are knowledgeable about this area of law in Nigeria the opportunity to create precedents. Also give people like you and I the opportunity to actually practice our work, because the truth is that Nigerians don't value services. So even if you want to give them a VVIP treat, and you call a fee that you feel, oh, it's affordable, the cost is not something that they need to buy. They're not seeing what you're doing. No one wants to pay, because one, they've looked at you and they size you. You're not yet a silk and you're charging me this. Why should I pay? So which is where your skill of persuasion
comes into play, where you have to convince and to talk. Sometimes you're being talked down on, but you just have to overlook it and focus on the end goal, which is I need to make money and I need to make my clients happy. So in conclusion, IP registration is cheap and is not cheap, depending on the agent you use. Registration is stressful, just like how sales registration is stressing everybody out now. I know we had the stakeholders with the registries. I know the Trademark Registry said they're working on their platform, because a lot of people have been complaining about registration on the platforms. When it comes to resolving IP disputes, I'm a dispute resolution practitioner. I'm an administrator by training, so I always opt for ADR. Now, the case that I like to use as example, because it's in the creative space, is the blackface against two-face case that was resolved after 10 years at the Lagos Municipal Courthouse. So if you're based in Lagos, Lagos has a lot of ADR centers. You have the regional center, you have Lagos Court of Arbitration, you have Lagos Municipal Courthouse. You also have the Chartered Institute of Arbitrators, you have the Institute of Chartered Litigators and Consultants as well. Then you can also be on the lookout for law firms that do all of this. So you also have to show and prove why I, as a mentor, as a law firm, need to give you an opportunity out of everything. Because I've gotten requests for interns, and I thought like them, I don't think I'm there yet where I would like to take an intern. But if I have, a huge load on my table, I'll definitely take one. Mentorship can always be done informally. I'm not big on he's my mentor, that's my mentor, whatever. Read, connect. The internet is like your best place not to meet anybody. Most of my IP contacts, I met most of them on Twitter and on LinkedIn. It's not difficult for you to access people. Just send in a message. The person responds to you, fine. I don't answer one-line message. Good morning, ma. I'm not even big of people calling me ma. Good morning, ma. Then you stop there. You're waiting for them to say good morning, how are you doing? Or you come and say good morning there or good afternoon there. When I see good morning there, you have lost me in that one. I'll probably just leave you a read. It's not because I'm rude or I'm saucy or I'm slow. It's because I just feel you're wasting my time. If you're going to actually engage me, write a full paragraph for me. So when I'm reading, I know this person is serious in what he or she is doing. I wants to learn. Let's spread the message that enforcement, IP can be enforced in Nigeria. When it comes to enforcement and arbitration, so people have this idea that you can't enforce arbitral awards in Nigeria. That's not true, please. That's not true. That we'll keep having we'll make Nigeria like the next this resolution hub in Africa. So I guess I'll just stop here for now. If we have questions, just let me know.
Thank you very much, Rita. Thank you so much.
Okay.
I'm not sure if Jude is still here.
Yes,
Okay.
I am. Okay, we thank our mentors so much for the insightful knowledge they have shared with us. I believe our mentees will have learned a lot from that. That's the difference with those who are doing it practically and some of us who are still just researching. So there is one question here from the mentees, and I'll be directing this question to Mr. Shea to respond to. The question goes, is there any time limitation or limitation period for a person to institute an action regarding the infringement of intellectual property? Let me repeat that. Is there a time limitation or a period for a person to institute an action regarding the infringement of IP? Mr. Shea, thank you.
All right. Thank you so much, moderator, for the question. Going through the Nigerian laws on IP, I cannot lay my hand on one that says there's a time within which you can come to enforce your rights in perhaps for infringement of IP. However, we must make a recourse to statute of limitation for general contracts. That one provides that you must, of course, make moves to enforce, to seek the damages for breach of contract within 6 years of that breach. So within 6 years where you notice that breach, that breach has occurred, you must make moves to get damages. So linking this now with IP, we know that when IP is infringed, most times it is a continuous action. when somebody infringes your copyright, most times it's a continuous action. You know, from the point where you discover, from the point where you discover it, and then you reach out to the proposed defendant now of your grievances, your time starts counting. Okay, and of course, if they continue in that breach, they continue in that infringement. So that means your time just keeps running perpetually. But if there is a contract between you and another, an IP-related contract, no, you sign contract between you, a licensor now, and another licensee. The moment a breach occurs, so the other one now takes us to the balance of contract. So that one now, such of limitation can apply, and then you have 6 years within which you must try to enforce your right or get damages in that. So there's a distinction between IP infringement on the face of it, and then contractual relationship that has IP coloration. Okay, so there is none for IP generally, but there's a contract between you and another party. So then you have 6 years within which you must make move to enforce or get damages for that breach of contracts. I hope that answers the question. Thank you.
Okay, thank you so much for your response. We'll be rounding up soon, but before that, we have some announcement there that I should take note of. To our mentees, know that the private mentorship with mentors is still available. The information will be shared on your group. And also, the registration for Q2 of the mentorship session is on. Do endeavor to share with your friends and colleagues. I want to take this opportunity to thank everyone who has attended the convener, Juliana. We thank our mentors, Rita and Shei, and all the groups that presented and everyone that also shared their screens. We wish you a wonderful weekend ahead. Thank you very much.
Thank you very much, Jude, for an amazing anchorship or anchoring. I'm not even sure the exact English, but I want to say thank you. Thank you so much. Thank you, Rita. You're just amazing. You know a lot about this, and it's very clear in your speech and your delivery. Thank you so much. Also, I want to thank Shei. Shei is on the job, he's practicing, and he knows a lot about it also. Thank you, thank you, thank you. And to all the beautiful and handsome mentees, thank you so much for staying till this time. Thank you for burning the data and ensuring that you learn. And please, when you listen to people like this speak, try to see that you take advantage of the private mentorship to meet with them and actually learn more, because it's not everything that they will share here. So during their free time, they can tell you more about it. But one thing I would say is, let us not be scared. Nobody learns everything in a day. Everything is small, small, gradually and all that. So if you're already practicing as a young practitioner, when you get something new, feel free to reach out to those ahead of you. That's the reason why we have this platform. And as students, what you're doing is actually good. So when you come out, it will be easier for you. I want to wish everyone an amazing weekend. Take care of yourselves. Good night, everyone. Thanks, Rita. Thanks, Shei. Take care. Bye.
Bye. Thank you.
Thank you.
Bye.
Bye.